Lord, 370 starts with a non-obstante clause. There's nothing in this constitution. This is how the 370 would function. 370 sub-article 3 starts with a non-obstante clause, notwithstanding anything in the foregoing paragraphs, meaning thereby even 370 can be subjected to 370 sub-article 3. Kindly read it once again. I do not know.
Obviously, because 373 has 370 clause 3 has a non-obstante clause which overrides everything else in this in this article.
Even 1D.
Right.
Even 1D, which says that don't do anything except 1 and 3. And
there are two non-obstante clauses. The first is notwithstanding anything in this constitution. And 370 clause 3 says notwithstanding anything in this article. Therefore, it overrides, therefore, it's a power to override even clause 1.
Clause 1, yes. Clause 1, 2, 2 doesn't come. Lord, 1D also. Lord, your lordships, Lord, very illuminating.
But there can't be any doubt about it, because when 370 clause 3 says notwithstanding anything in this article, that would include clause 1. There's no
Lord, meaning thereby, modification in 370 itself was permissible through 367.
And when you override clause 1, the plain intent, therefore, is that the constitution itself becomes applicable then.
Correct.
Once you exercise the power under 3, whether there was a valid exercise is what we have to decide. But once you exercise validly the power under 3, then the constitution applies. That would be the plain consequence of it.
My Lord, your lordships may treat this as read. My Lord,
yes, we'll read it.
Let's
go now to the last point.
Only, my Lord,
last
reorganization, Mr. Lord, last 2 pages. My Lord, last 2 pages. The status of Constituent Assembly. What was the status of Constituent Assembly? Because nomenclature is a Constituent Assembly. But whether it enjoys, my Lord, I'm at the outset.
You're not saying that it is subordinate to the Constituent Assembly for the Union. I mean, you can't elevate that Constituent Assembly.
Lord, I must clarify one thing as an officer of the court. Lord, I'm conscious of the principle laid down in Keshwanand Bharti that there is a distinction between Constituent Assembly and Parliament, or Constituent Assembly and Legislature. They are not interchangeable. That's why, my Lord, this submission, that here Constituent Assembly for all intent and purpose was a legislative assembly, not preparing a document of governance for a sovereign region, but was, my Lord, kindly similar. There are some arguments based on, my Lord, the judgment also, my Lord. My Lord, the position as far as the state of Jammu and Kashmir is concerned, even prior to coming into force of Article 1, was who created Constituent Assembly? The Maharaja, who signed instrument of accession and surrendered his sovereignty. Then he issued that proclamation. Your lordships are, my Lord, remembering that now whatever constitution is framed would be binding on him. He subsequently, my Lord, creates a constituency. So he could never have created a Constituent Assembly which would have a role independent of, larger than, or completely different from the Constituent Assembly of which he became an integral part. And at that time, my Lord, the Jammu and Kashmir was an integral part of India. So the body which was created was known as Constituent Assembly, but was a subordinate creature, then, my Lord, Constituent Assembly. And the Constitution of Jammu and Kashmir can never be put at the same pedestal as the Constitution of India, because the very birth of the Constituent Assembly of Jammu and Kashmir was because of Article 370. And
in other words, according to you, the role of the Constituent Assembly of Jammu and Kashmir is the role which is created for it by our Constitution, by the Constitution of India, nothing beyond that.
It cannot be beyond that, above that, or superior to that. It is subservient and subordinate. It never had original constituent power. Lord, please see, my Lord, the Constitution as we understand around the world, Lord, has certain attributes, namely, it must be a document of governance, providing for everything, the way, my Lord, we have provided. This Constitution has only certain aspects. Rest, my Lord, they leave it to the Constitution of India. For being recognized as a constitution, you must provide for a kind of sovereignty. I'm not on, my Lord, sovereignty means sovereignty, my Lord. It's not autonomy. And sovereignty would mean right to acquire new areas and right to cede new areas, right to acquire territory and right to cede territories, which we have in Article 1, 2, 3, 4. Constitution of India has. Lord, none of the attributes of a constitution, so to say, Lord, can be attached to this constitution. It was a piece of legislature recognized, accepted, and known till 5th of August and 6th of August 2019 as constitution. But for all intent and purposes, my lord, it was, my lord, even the preamble of the constitution doesn't say so. A preamble of constitution of Jammu and Kashmir doesn't say so. That this is a document which is a constitution. It merely says, Lord, please see the the preamble of Jammu and Kashmir constitution. It says, with a view to further define our relationship with Union of India. It doesn't say that we are creating a constitution of our governance. Please see, Lord, that's the only purpose. They say, we the people of Jammu and Kashmir, with a view to, I'll just read for your lordship, my lord. I'll just read, my lord. It is, kindly note the page. Even preamble doesn't say that it has attributes of a constitution per se. We, the people of the state of Jammu and Kashmir.
Mr. Solicitor, there is another more fundamental reason why your argument may be correct, which is this. Look at Section 5 of the J&K Constitution. It says the executive and legislative power of the state extends to all matters except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India. So once the Constitution of India defines which is the area in respect of which Parliament has the power to make laws, then that is denuded from the jurisdiction of the Jammu and Kashmir Legislative Assembly. Now, we have seen how progressively the ambit of the legislative domain of Parliament was expanded. For instance, initially the entire concurrent list was outside the power of Parliament.
Correct.
You had only certain entries in List 1, the Union List.
I am obliged.
Right? Subsequently, the concurrent list was brought in. Once the concurrent list is brought in within the domain of Parliament, to that extent, the legislative domain of the Jammu and Kashmir Legislative Assembly is denuded. Then entry 97 was wholly outside the purview of Parliament initially. Later on, as we see, entry 97 is also gradually brought in within the purview of Parliament, albeit in the context of laws affecting the sovereignty and integrity of India,
some subject,
terrorism, so on and so forth. Therefore, it's very obvious from Section 5 of the J&K Constitution that once the Constitution of India prescribes a certain legislative domain for Parliament, then that is progressively denuded from the legislative ambit of the J&K Legislative Assembly. And that was not fixed as of 1957. Another very important feature is that Section 5 does not fix the ambit of the legislative or executive domain of the J&K government and the Legislative Assembly as of 26th of January 1957.
Correct.
In fact, it contemplates that what the Constitution of India will prescribe for Parliament will be outside the domain of the
of our domain.
In that sense, it was always intended to be subservient to the Constitution of India.
And my lord,
it's not really a document which has equivalent effect.
And that's what the 147 makes these provisions unamendable. Section 147. 3 and 5 cannot be amended. Otherwise, what happens? Lord, this is amendable. This constitution, if it would have survived, was amendable by the Legislative Assembly. So they can amend their preamble and academically, potentially, can become a theocratic state because secularism was not applicable.
All right, Mr. Solicitor, I think we've gone through your Article 370 note. Now, what your Constituent Assembly note? Now, what's about?
Now, Lord,
now you have to deal with the important part about states reorganization and the conversion of the state into a UT. How do you answer that?
Lord, I'll take a little time on this one, not unrealistic time, but there are 3-4 judgments, which are direct judgments.
All right.
Well, your lordships would bear in mind the difference between our constitution and, say, Constitution of America, where there is a contract between the state and the federal government, and that is how they form the United States. The federal government doesn't have the power to even alter the boundaries of the states because it's a different and distinct
There was no contract between the states and the federal government in the US.
Intern.
The 13 colonies came together to form a union, and they surrendered some powers to the union.
To the union. Otherwise, retaining, my lord, some of the states have its own Supreme Court, etc. My lord, whenever, my lord, a nation like ours and the federalism which we have accepted, which is, my lord, kind of leaning towards unitary feature. I'm not arguing on that unitary versus federalism. But at times, the nation requires to rejudge the boundaries and the status of their states. But there are several considerations. And therefore, at the outset, my lord, I may point out that this is a case, one of its type, which is not to be encountered, my lord, by the court. For example, if Gujarat was to be bifurcated or Madhya Pradesh was to be bifurcated, the parameters would be different. But when Jammu and Kashmir, considering its very strategic importance, border state, history of terrorism, history of infiltrations, history of outside influence, outside means outside the country, etc., etc., there would be several considerations in the mind of the government. We share border with 4 at least countries, all of which may not be friendly, to put it mildly.
Argument based on border states is a problem. We have many states on the border.
No, history also. The history, I have given the details in my affidavit, filed long back, how the situation in Kashmir is developing. The number of deaths of civilians, the number of deaths of security forces, the number of attacks, the number of stone pelting, the number of every week 2 or 3 days of hartal, paralyzing schools, hospitals, banks, business houses, everything. All these are policy considerations. Whenever a state reorganization takes place, not only there are policy considerations as to why the state needs to be reorganized, but there is always a blueprint as to what the central government would do after the state is reorganized. How to bring, in a peculiar facts of this case, the youth in the mainstream, how to ensure that they are gainfully employed, how to float certain schemes so that people on the bordering or who are continuous, facing the attacks of shelling, etc., are now getting a sense of confidence that the government has not left us, etc. There are several considerations that we will have to start with, say, democratic local self-government elections so that the people participate in the internal local self-government institutions for their own good.